May I be permitted to mention item number 54, my lord? This matter was mentioned on September 6th by Mr. Moinak Bose, learned counsel for the respondent, and your lordship was pleased to upgrade this matter. On Wednesday, it was appearing as item number 50.
No. In fact, the court officer has informed.
It has gone down today in the list.
No. For some reason, sir. Please accommodate the court also. Next week, it will retain its old position. Yes.
May I have my lords kind leave to mention a matter, my lord? This is a matter which I had mentioned. Your lordship, so please to, my lord, allow the listing, but my lord, it has not come up in the list, my lord. My lord, it was there in the list, my lord. On the last time, my lord, when we had mentioned, we had explained, my lord. There was a date which was given previously, my lord.
20th it will come.
20th it was fixed, my lord. It will come back on that day, my lord. I'm deeply obliged. My lord, may I hand over the slips? Deeply obliged.
What do you say, Delhi statute number 1?
Yes, my lord, with the, with your kind indulgence, I am able to convince my clients to come and settle at 50 lakh. Just one prayer that it must be at once and before the vacation. This is our only submission.
And my instructions are to play for at least 6 months' time to pay it off. That will be a little too much.
Don't be
That will be too
unreasonable.
much. That will be too much.
Don't be unreasonable.
No. That kindly gives us 3 months' time, we'll pay it off. In 3 months, we'll pay it off.
You paid before 31st October. First, out of 50 lakhs, 50% of that, you please pay by 30th September.
Gives me 1 minute. Just give me 1 minute.
No, please, you please be reasonable also, sir. They have come down. He is also not, he may be a very big contractor. Now he says he is in deep financial position.
Not, which we've checked his website. It's actually not true. We're carrying the printout.
Don't argue on those lines. Don't argue on those.
No,
Your client is a defaulter. That's it.
Yes.
Now that the appeal is pending.
3 months to pay off this amount.
Before 30th September, you show your bona fides. At least 20 lakhs you pay.
Very well. Yes.
My lord,
lakhs I'll pay.
20
and the
lakhs.
rest amount in 2 months, another 2 months, you'll
We pay the 20 lakhs.
Yes.
And then the matter is
We will list the matter.
returnable, my lord.
The parties have, the MSME has agreed to accept a total sum of rupees 50 lakhs as full and final settlement towards the interest rate, and request that the entire money be paid before 30th September 2024. The learned advocate appearing for the appellant hospital submitted that they are in deep financial trouble and they will be unable to pay the entire sum as before 30th September 2024. In order to give a quietus to the matter, and also taking note of the fact that the MSME has been reasonable in accepting the suggestion given by this court, the appellant hospital is directed to pay a sum of rupees 20 lakhs either by bank transfer or by demand draft drawn in favor of the respondent MSME by 30th September 2024. Anjan, we have got original side day is Tuesday, Wednesday, but Wednesday is a holiday. Friday, 4th camp. Listen. List under the same caption on 4th October.
Very good.
Yes.
Obliged.
Thank you.
Item number 3.
Bring this matter, I appear on behalf of the appellant.
Lord, I am for the union.
Lord,
It's a fresh matter, or we heard the matter earlier?
no, your lordship are pleased to say that the matter requires to be decided. So the appeal be listed as to be mentioned. It appeared,
To be mentioned.
Ah.
How much time both of you?
I don't think it should take much time.
Within 1 hour will be
Yes, certainly.
both sides.
I think so.
I shall not take more than half an hour.
I think so. But the point is very simple. I tell your lordship need not open the brief right now. I shall take your lordship to the relevant pages. Lord, there were 2 criminal cases against the appellant. In one, he was convicted and sentenced, went up in appeal before the Delhi High Court. That was stayed. Another was before NIA, Court at Ranchi. That is still pending. Now, in the meantime, the passport was going to expire of the appellant. So, as required by law, you have to have permission from the courts where criminal proceedings are pending. So I made an application before the Delhi High Court as also before NIA. Both the authorities permitted renewal, saying that you won't leave the country without taking leave of the court. I shall place those 2 orders. Okay. In spite of that, my passport was not being renewed. So I came to this court saying that these are 2 orders of Delhi High Court and NIA, Ranchi. Even then, the passport authorities are not renewing. The Honorable Single Judge made out a 3rd case, which was not consideration, and differed with 2 High Court judgments, followed another High Court judgment, and said the law does not provide for renewal, which means the learned judge was sitting in judgment over the Delhi High Court order.
But why did the petitioner move this court when all other proceedings were moved before the Delhi High Court? Or
The passport authority issuing authority is here. Passport authority issuing authority is here. And look, there is no quarrel on this score between the parties.
then we can do that. Not much of urgency.
Yes, my lord.
Why?
Number 1, it has to be renewed, and if I have to go for business reasons a number of times every year. Now, without the permission, I cannot go. And until it is renewed, I can ask for permission.
No, the matter is pending before the Delhi High Court.
Yes.
Appeal is pending.
Yes,
And in that appeal, you got permission,
yes.
and you can very well move the Delhi High Court, and you could have got an order.
No, but only thing is, Delhi High Court, what is pending is the criminal proceeding. Appeal from a criminal conviction.
That is correct.
And here, the criminal court will not have a power to direct and exercise powers as are available with the court under Article 226.
No, the Delhi High Court, page number 37 has granted permission.
Yes.
And you could have filed a miscellaneous application in the very same appeal, criminal appeal 189, and you could have got a permission. Instead of coming here, you could have implemented the Regional Passport Authority, Calcutta, as one of the respondent there with the leave of the court.
But in that event, the order of the learned single judge shall stare in the face. If your lordship so wants that we go before the Delhi High Court, your lordship will have to set aside the order of the learned single judge and then send us to Delhi High Court. But so long as that remains, that stares in the face. The Delhi High Court will say something.
No, the petitioner took the risk and now he is agreed.
Take the risk. It was not a point that it is not maintainable here. And in fact, it is maintainable. Is admitted. Both parties advanced arguments, not on maintainability. But the learned judge.
We'll do one thing, sir. We'll immediately on the reopening, we'll list. because the next 2 weeks will be very difficult. There's already three.
My lord, as a lawyer, I cannot say no, but we are deleting this
That is
otherwise.
correct. And the writ petition was decided sometime in May 2024, 1 month time. So we will list the matter on 8th November. List the appeal on 8th November. We'll hear the appeal.
My lord, I leave it to your lordship because I have never bargained in my life with the court.
No, not
Yep.
that. We are also requesting. 16th is a holiday, Monday. So that week we got only 4 days. Then the last week they will say this urgency, that urgency. That is why today we have pushed the part heard matter or continuing matter below the admissions.
Lord, in that event, may I make this prayer? On that day, let it appear as the first matter as was appearing.
Yes. List the matter for hearing on 8th November, higher on board.
8th November.
As it will appear as the first matter.
Yes, higher on board. So some miscellaneous condone delay, this, that will be there.
Grateful to your lordship.
Item number 4.
Recalling application.
Milord, in this matter, Milord, I was informed by learned friend that it, as per your lordship's direction, I am appearing, Milord. In this matter, I have not been appearing, Milord. Because of the very same SSC, I had appeared before a matter with your lordship sitting before court number 16, but not in this matter, Milord.
But
I
we
have
have,
no instructions in this.
Malad, we have served Milord affidavit. Malad, service is completed. But your lordship last occasion, Milord, asked me to Milord call Mr.
Yes,
Sen, Milord, take instruction, Milord. I also Milord intimate him, Milord.
But he is not, he doesn't have instructions to
But
appear.
affidavit service is there, Milord. We have served.
Registration we can allow. What is the appeal? Please give the paper book. What are the questions of law? Whether in facts and circumstances of the case, learned tribunal applied 206C properly in holding the liabilities thereunto did not arise in case of traders in sawn timber. Only admitted on only one question.
My lord.
But there were 2 assessment years. 2 appeals have been filed? No.
No, perhaps one appeal has been filed. Yes. Hmm.
Tribunal followed a earlier decision of the coordinate bench in ITA 249-253 of 2013. And the coordinate bench decision was in the assessee's own case for the assessment year 2005-6 to 9-10.
That is true, Milord.
Time.
So at least consistent approach should be there. Please come. Sir. This application, GA 3 of 2024, this application has been filed to restore the appeal, which was dismissed for non-prosecution and dismissed for default by order dated 1/7/2024. We are satisfied with the reasons given in the affidavit filed by the department, and the application is allowed and the appeal is restored to the file of this court. Then in the main appeal, ITA number 24 of 2020. This appeal has been filed by the revenue against the order dated 15/12/2017, passed by the Income Tax Appellate Tribunal C Bench Kolkata in ITA numbers 96-98/KOL/2016 for the assessment years 2010-11 to 2012-13. The appeal was admitted on 22nd January 2020 on the following substantial question of law. Page 119 of the paper book, I'll mark with pencil. We have heard Mr. Soman Bhattacharjee, learned senior standing counsel for the appellate. Your name?
Time is not recorded.
Though the respondent has been served, none appears for the appellate. After we have elaborately heard the learned advocate for the appellant department and carefully perused the materials placed on record, and in particular, the order and reasoning given by the learned tribunal, we find that the decision rendered by the tribunal cannot be faulted. Apart from other reasons, the learned tribunal has followed the assessee's own case, for the assessment years 2005-06 to 2009-010 on the very same issue, and the decision was rendered in favor of the assessee, and the decision has become final. Thus, when the nature of transaction was identical and the issue was already concluded by the order passed by the learned tribunal in the assessee's own case by order dated 6/4/2016, we are of the view that the tribunal was justified in following the said order. Apart from that, the learned tribunal has also taken note of the decision of the Honorable Supreme Court in Aspin Wall and Company Limited versus CIT 25 ITR 323 within bracket SC. And the decision in Deputy CIT versus PIO Food Packers 46 STC 63 within bracket SC. The learned tribunal has also taken note of the decision of this court in an identical case in Shaw Brothers SHAW and Company versus State of West Bengal 1963 14 STC 878 within bracket Calcutta. Thus, we find that the learned tribunal was right in allowing the assessee's appeal. For the above reasons, the appeal filed with the revenue is dismissed and the substantial question of law is answered against them. Yes. Next.
Right now, 5.
Yes.
May it please, Your Lordship.
this is a matter, my lord, wherein, my lord, your lordship need to, my lord, see whether, my lord, the exception clause, my lord, appearing in section 80 IA, which is as a whole as a clause giving exemption to the assessee, how, my lord, the sub clause 4 of that section is to be seen. Now, my lord, section 4, if I, my lord, first of all, place that sub clause, which is, my lord, the moot of the entire controversies.
Income tax. Section,
Section 80 IA sub clause 4, my lord. My lord, I've got it, my lord, section 80 IA.
we should see the provision
Sub,
prior to the amendment, no?
yes. This is, my lord, with regard to, my lord, the agreement that has to be entered by the assessee with the government, more specifically, my lord, subsection 4,
No, no.
clause B.
By Finance Act 1999, there was some amendment.
Yes.
And we have to refer to the position prior to that is no.
Well, our assessment is a 15, 16,
No, this is
16, 17.
subsequent to that.
The
So we have to,
present statute.
Present statute, my lord, the subsequent to that.
ATIA4, this section
80
applies,
IA 4,
this section applies to, correct?
yes.
Hmm.
And the controversies, my lord, surrounding subsection 4 of that section, wherein, my lord, a condition has been, my lord, stipulated with regard to, my lord, the assessee claiming benefit under the section. My lord, this subsection, my lord, actually narrow down, my lord, the conditions under which, my lord, the assessee can claim benefit as enumerated in the entire section. Subsection 4, clause B, to be more specific, wherein, my lord, it, as it runs like, it has entered into an agreement with the central government or a state government or a local authority or any other statutory body for developing or operating and maintaining or developing, operating and maintaining a new infrastructure facility. Now, my lord, the instant case in hand, my lord, the assessee did not comply these conditions. It has got an agreement, my lord, but that is not in accordance with these provisions, not with the central government or with the state government or with any other statutory body. First of all, my lord, kindly have a look, my lord, the statement of the assessee regarding this factual aspect as recorded in the assessment order. The lordship, kindly turn to page 59 of the stay petition. My lord, I am referring to paragraph 3.2.1 of the set page. Wherein, my lord, the assessing company in the present case is an Indian company, my lord, the assessing officer and, my lord, gone on to, my lord, describe the backdrop, and, my lord, in the mid of that para, the contention of the assessee before, my lord, the assessing officer has been recorded. I'm just, my lord, placing the relevant portion. The agreement dated 28th January 2009 between Kakinada Seaport Private Limited and Government of Andhra Pradesh for development of Kakinada Port, which has enabled the agreement between Kakinada Seaport Private Limited and Bothra Shipping Service Private Limited for the development of maintaining cool handling system has been treated as agreement with the state government in compliance with section 80 IA4 IB and for the purpose of certifying deduction in form 10 CCB. Even otherwise, since Bothra Shipping Service Private Limited is engaged in operations and maintenance of the infrastructure facility, they are also falling within the meaning of proviso to section 80 IA4 and thus was considered eligible for deduction for the purpose of certifying claim of deduction under section 80 IA in form 10 CCB. So, my lord, there has been, as per my lord, as it is appearing from my lord, the condition of the SSC, there are twofold submission. Either in the first limb, they, my lord, intend to, my lord, indicate that agreement should be deemed to be an agreement with the state government. Or if that fails, my lord, then it should be that the contention of the SSC that it should be construed to have been, they are falling under the purview of the intersection as a whole. These are the, my lord, factual aspect which, my lord, the SSC have placed during the course of assessment. Then, my lord, I shall, my lord, also indicate the very next paragraph. However, according to the CA, since the agreement with KSPL was a subset of the latest agreement with the government of Andhra Pradesh, he found it fit to certify the claim of deduction under 80IA 4 of the Act. The SSC was thereafter confronted with this disclosure given by the chartered accountant and was required to explain as to whether it satisfied the conditions prescribed in section 80IA 4 of the Act. In the reply furnished, the SSC tactically admitted that although all the conditions were not fully satisfied, but they were substantially complied with, referring to judicial decisions rendered by the Honorable ITAT Hyderabad in the case of Balear Logistics Limited versus Ocean Sprite Limited, the SSC claimed that the deduction under section 80IA as claimed in terms of the income was permissible. So, like, this has been, my lord, the contention of the SSC before the, my lord, the assessing officer, indicating that either either, my lord, the agreement that has been, my lord, carried out with an entity which has actually entered into an agreement with the authority as per the statute should be deemed to be an agreement with the authority as well. Or even if it is falling outside that ambit, then, my lord, the interpretation should be, my lord, advanced to that extent so that the benefit under the intersection should be given to the SSC. This is, my lord, the moot questions, my lord, wherein, my lord, with regard to the interpretation of 80IA 4. Now, my lord, certain relevant pronouncement in this regard is, my lord, I am intending to place before your lordship. And, my lord, I have prepared a compilations with regard to this issue because this has not been practically decided by the any court. দুটো সেট আছে আর দুটো ডকুমেন্ট লুজ আছে এই লজিস্টিকটা দিয়ে দিয়েছি তোমারটা দিয়ে দিয়েছি না এল লজিস্টিক আছে তোমার কাছে এল লজিস্টিক
I think all these propositions are well settled.
Yes, my lord, the question is
Court has to see the words in the statute, not
yes.
the spirit. Court cannot import, no presumption of tax. Equitable considerations are wholly out. There is no equity in physical statute. The intention of the legislature is primary. Tax and equity is a stranger. Taxing statute should be interpreted in accordance with the ordinary and natural meaning. Physical legislature should be interpreted in accordance with strict rule of
Of
interpretation. Hardship is not relevant. We well settled.
Yes, my lord.
They cannot have any quarrel. on
Possibly, if I could, my lord, only indicate, but this is, my lord, the perfect situation wherein, my lord, your lordship need to, my lord, actually ascertain whether, my lord, the any departure from the, my lord, the state and simple meaning of the word used by the statute can be permissible or not for, my lord, to give any, my lord, the extending the benefit of the statute. Because, my lord, this has to be, my lord, given in effect with regard to, my lord, the strict rule of interpretations. And, my lord, there is, my lord, possibly no scope of, my lord, importing anything, my lord, extending any benefit that is not, my lord, meant within the statute. The conditions, my lord, that is apparent on the face of the book, my lord, should be, my lord, given a strict interpretation, and, my lord, cannot be extended in any, because that has been, my lord, fallen from the courts from time to time. That is, my lord, what I have, my lord, indicated in the compilations. It starts from, my lord, the old one, that is of 1940 SCC online Privy Council, wherein, my lord, the court is to see the words of the statute and not of the spirit, no interference, no analogy. My lord, the specific paragraph is 3 and 4. Page 3 and page 4, my lord, is the relevant portion wherein, my lord,
Yes.
then, my lord, I shall be coming to, my lord, SCC 1957 online Supreme Court 23, where, my lord, it has been, my lord, decided that court cannot import anything while interpreting a revenue statute. That is, my lord, appearing at page 8 to 20, that judgment in my compilations, and relevant pages is page 14 and 15. I'm placing that before lordship. Page 14 of my compilations, my lord. I'm placing that. The answer given by the learned counsel for the appellant to the above reasoning was that in fiscal statute, what you have got to look to is not the spirit of the statute, but the letter of the law. And if you could not bring a particular tax within the letter of the law, the subject could not be made liable for the same. Our attention was drawn on this correction to the observations of Lord Russell of Kilonell in Inland Revenue Commissioners versus Duke Watts, Westminster. I confess that I view with disfavor the doctrine that taxation cases the subject is to be taxed if in accordance with the court's view of what it considers the substance of the transactions, the court thinks that the case falls within the contemplations or spirit of the statute. The subject is not taxable by inference or by analogy, but only by the plain words of the statute applicable to the facts and circumstances of this case, as Lord Claims said many years ago in Protington versus Attorney General. If the person subject to tax comes within the letter of the law, he must be taxed. However great the hardship may appear to the judicial mind to be. On the other hand, if the crown seeks to recover the tax, cannot bring the subject within the letter of the law, the subject is free. However, apparently within the spirit of the law, the case this might otherwise appear to be. The passage was quoted to approval of the Privy Council in Bank of Chittenden versus Income Tax Commissioner, and the Privy Council registered its protest against the suggestion that in revenue cases, the substance of the matter may be regarded as distinguished from the strict legal position. It is no doubt true that in construing fiscal statute and in determining the liability of a subject to tax, one must have regard to the strict letter of the law and not merely to the spirit of the statute or the substances of the law. If the revenue satisfies the court that the case falls strictly within the provisions of the law, the subject can be taxed. If, on the other hand, the case is not covered within the four corners of the provisions of the taxing statute, no tax can be imposed by inference or by analogy or by trying to probe into the intentions of the legislature and by considering what was the substance of the matter. We must of necessity, therefore, have regard to the actual provisions of the Act and the rules made thereunder before we can come to the conclusion that the appellant was liable to assessment as contended by the sale tax authorities. Then I shall be relying on pronouncement of 1964 SCC Online Supreme Court 48, Banarasi Devi, my lord. It's appearing at page 21 to 28 of my compilations. And the relevant portion is page 23, paragraph 6. Before construing the section, it will be useful to notice the relevant rules of constructions of a fiscal statute. In Oriental Bank versus Wright, the Judicial Committee held that if a statute professed to impose a charge, the intention to impose a charge, subject must be shown by clear and unambiguous language. In the words of Railway Justice, in a taxing act, one has to look at which is clearly set. There is no room for any intentment. There is no equity about tax. There is no presumption as to tax. Nothing is to be read in. Nothing is to be implied. One can only look fairly at the language used. In other words, a taxing statute must be couched in express and unambiguous language. The same rule of construction has been accepted by this court in Garshai Shanghai versus CIT, wherein it was stated it is well recognized that the rule of construction that if a case is not covered within the four corners of the provisions of a taxing statute, no tax can be imposed by inference or by analogy or by trying to probe into the intentions of the legislature, and by considering what was the substance of the matter, applies only to a taxing provisions and has no application to all provisions in a taxing statute. It does not apply to a provision not creating any charge for the tax, but laying down the machinery for its calculation or procedures for its collection. The provision in a taxing statute dealing with the machinery for assessment have to be construed by the ordinary rules of construction. That is to say, in accordance with the clear intention of the legislature, which is to make a charge levied effective. In that case, the court was called upon to construe the provisions of Section 18A of Income Tax Act 1922, which laid down the machinery for assessing the amount of interest, and therefore the court did not apply the stringent rule of construction. Apart from the emphasis on the letter of the law, the fundamental rule of constructions of a taxing statute is not different from that of any other statute, and the rule is stated by Lord Russell of Killian, Chief Justice in Attorney General versus Calton Bank. Thus, the duty of the court is to give effect to the intention of the legislature, as that intention is to be gathered from the language employed, having regard to the context in connection with which it is employed. To the present case, the general rule of construction of fiscal acts would apply, and not the exception engrafted on that rule. For Section 4 of the amending act cannot be described as the provision laying down the machinery for the calculation of tax. I'm skipping that portion, my lord. Then, my lord, I'm relying on CIT Bombay versus Maharashtra Sugar Mill, reported in 1971, volume 3, SCC 543. My running page is page 29 to 36. I'm placing paragraph number 3 appearing at page 31 of my compilations. The finding of the tribunal that the cultivation of sugarcane as well as the manufacture of sugar constitutes one business is a finding of fact. The finding has not been challenged before us. What was argued and on behalf of the department is that the assessor's business consisted of two parts, namely cultivation of sugarcane.
You can skip that
I will
and
see.
come around 6 lines below to find out whether a deduction claimed is permissible under the act or not. That sentence you have got?
Yes, yes, yes.
8 or 9 lines down, middle of that para. This contention.
Yes, to find out whether a deduction claimed as permissible under the act or not, all that we have to do is to examine the relevant provisions of the act. Equitable considerations are wholly out of place in construing the provisions of the taxing statute. We have to take the provision of the statute as they stand. If the allowances claimed is permissible under that, then the same has to be deducted from the gross profit. If it is not permissible under that, it has to be rejected. As mentioned earlier, it is not disputed that the cultivation of the sugarcane and the manufacture sugar constitute one single and indivisible business. I may skip this one because that is not relevant.
Next
Now, let
page 37. Controller of
that is
estate.
controller of estate duty versus Kantilal Tirakmal, page 37.
Para 20, page 48.
I'm grateful, man. Before we enter into the thicket of judicial conflict regarding the meaning of property as extended by explanation 2 of section 215, we may remind ourselves as courts that in a taxing statute, one has to look merely at what is clearly said. There is no room for any intendment. There is no equity about a tax, while the ruling on the point of act and in the Allied Gift Tax Act will be averted to presently, we may begin an incisive understanding of explanation 2 as aforesaid. The spirit thereof is obvious. The framers of the act desired by deeming provisions regarding depositions to cover extinguishments of debts and all other rights at the expenses of and made by the deceased in favor of the beneficiary. The substantive definitions of property My lord, I may skip this one because this is actually, my lord, canvassing the very same principle. Then, my lord, I shall be coming to, my lord, the next one. Srimati
1976.
Torutala Sham versus CIT West Bengal, 1977, volume 3, SCC 305. Relevant pages 65 and 66, my lord. Paragraph 34, my lord, I'm placing. We have given anxious thought to the persuasive arguments of Mr. Sharma. His argument, if accepted, will certainly soften the rigors of the extremely drastic provisions and bring it more in conformity with the logic and equity. But the language of section 26AE and 12IB is clear and unambiguous. There is no scope for importing into the statute words which are not there. Such importation would be not to construe, but to amend the statute. Even if there be a casus omissus, the defect can be remedied only by the legislation and not by the judicial interpretation. To us, there appears no justification to depart from the normal rule of constructions according to which the intention of the legislature is primarily to be gathered from the words used in the statute. It will be well to recall the words of Raul Justice in Cape Brandy Syndicate versus IRC at page 71, that in a taxing act, one has to look merely at what is clearly said. There is no room for any intendment. There is no equity about a tax. There is no presumption as to tax. Nothing is to be read in. Nothing is to be implied. One can only look fairly at the language used. Once it is shown that the case of the assessee comes within the letter of the law, he must be taxed. However great the hardship may appear to the judicial mind to be. Then, my lord, I am relying to Vikrant Tyers, reported in 2001, volume 3, SCC, page 76. Relevant pages, page 82.
No, relevant pages, page 77.
And that is at the beginning of the citation. Yes, 77.
No, you skipped one.
Yes.
Kapil Mohan versus CIT, para 13.
Para 13. I'm getting.
It has long been recognized that tax and equity are strangers.
Yes.
Just as reliance upon equity does not avail an assessee, so it does not avail the revenue. Only those 3 lines.
Only those 3 lines.
Then next is
Hansrachans versus State of Jammu and Kashmir. That is, my lord, 2002, volume 6, SCC 227. And the relevant pages, page 94 to 96. Paragraph 22, appearing at page 94. A constitutional bench of this court, in case of A.B. Fernandez versus State of Kerala, observed, it is no doubt true that in construing fiscal statute and in determining the liability of a subject to tax, one must have regard to the strict letter of the law and not merely to the spirit of the statute or the substance of the law. If the revenue satisfies the court that the case falls strictly within the provisions of the law, the subject can be taxed. If, on the other hand, the case is not covered within the 4 corners of the provisions of the taxing statute, no tax can be imposed by inference or by analogy or by trying to prove into the intention of the legislature and by considering what was substance of the matter. We must necessarily, therefore, have regard to the actual provisions of the Act and the rules made thereunder before we can come to the conclusion that the appellant was liable to assessment as contended by the state tax authorities. In that case, this court also noted with approval the following observations of Lord Russell's Kelvin in IRC versus Dwight. This one, my lord, I have placed in the earlier one. Then, my lord, it goes on to produce, my lord, a similar view was taken in CWT versus Elias Bridge Gymkhana, in which it was observed that the rule of constructions of a charging section is that before taxing any person, it must be shown that he falls within the ambit of the charging section by clear words and used in the section. No one can be taxed by implications. A charging section has to be construed strictly. If a person has not been brought within the ambit of the charging section by clear words, he cannot be taxed at all. Then my lord, the next one, Government of Andhra Pradesh versus P. Lakshmi Devi, that has been reported in 2008, volume 4, SCC page 720,
Page 112.
112, my lord. I'm grateful, man. Paragraph 19, my lord. It is well settled that the stamp duty is a tax and hardship is not relevant in construing taxing statute, which are to be construed strictly. As often said, there is no equity in tax by CIT versus VMRP films. If the words used in a taxing statutes are clear, one cannot try to find out the intention and the object of the statute. Hence, the High Court failed in error in trying to go by the supposed object and intendment of the Stamp Act and by seeking to find out the hardship which will be caused to a party by impugned amendment of 1998. So, my lord, these judgments, my lord, have specifically, my lord, indicated, my lord, one aspect that nothing can be, my lord, read in, my lord. Nothing, the scope of the legislature, my lord, cannot be extended by any stage on following, my lord, any analogy. No equity, my lord, hardship is also not to be seen. The clear word, the strict word that is being used by the legislature, that is only can be seen. Otherwise, my lord, if any other intentions are to be, my lord, advanced, possibly, my lord, those are, my lord, the endeavor of the legislature. And if that has not been done, my lord, court is, my lord, restricted to the extent that it cannot, my lord, step beyond, my lord, the word used. So, my lord, here in the present case, the word used is very, very, very specific, while, my lord, imposing a conditions, while giving benefit, which was, my lord, the main subject of the intersection, which the exception clause, my lord, narrowed down, my lord, that condition. One has to come under this, otherwise, my lord,
He
that
should have
benefit.
entered into, your argument is, the assessee should have entered into an agreement with the central government or the state government or local authority
Yes,
for developing or operating, maintaining, developing, etc., new infrastructure.
yes.
There is no such agreement. This is and therefore the question of interpreting clause B of section 80 IA 4.
Man.
1.
Yes.
That should be strictly interpreted, and there is no room for intendment, etc. And if it is done, they are out.
Yes, because and that because I advanced this argument because of the fact they had got twofold of submissions. They had accepted the factual position that they never had. They are not complying with the conditions as stipulated in that subclause because they do not have that agreement as strictly mandated in that condition. They have tried to fit into themselves in a situation that it might have actually, my lord, covered their case being a beneficiary, otherwise falling under the entire purview of the section. But, my lord, to apply the entire, my lord, benefit of the section, that conditions as stipulated in 4(1)(b) are also, my lord, required to be strictly construed.
ওদের রিপ্লাইটা একবার দেখাও এই পেজ 63 তে ডিআরপির অর্ডারে আমাদের কোশ্চেন এগেইনস্ট ওদের রিপ্লাইটা দেখাও পেজ 63 পেজ 63 ওদের একটাই কন্টেনশন যে আমরা অন্ধ্রপ্রদেশ থেকে সার্টিফিকেট পেয়েছি পেজ 63 ইয়েস এইটা আমাদের কোশ্চেন ছিল ডিআরপি ও রিপ্লাইটা দেখাও
And, my lord, to, my lord, enlighten your lordship with regard to this particular fact, they have, my lord, the assessee had also filed a reply before, my lord, the tribunal,
ডিআরপি
before, my lord, the
পেজ 63
page 63, before DIT.
No.
Page 63.
Page 63, my lord.
পেজ 62 থেকে
It starts from, my lord, page 62, the bottom of that page, wherein, my lord, the reply of the assessee has been reproduced.
রিপ্লাইটা বহুত বড় এই রিপ্লাইটা
I'm placing, my lord, the relevant portion that is appearing under the Roman 3. Here, the assessee company did not enter into any agreement with the central government or the state government or the local authority or the specified authority. That such an agreement should be entered by the company availing the deduction under section 80 IA, whereas the instant case, it is the KSPL which entered into agreement with the government of Andhra Pradesh and not the assessee.
That's the question.
That's the question that has been put to the assessee. And, my lord, the reply of the assessee is, my lord, appended thereafter. As submitted earlier, the GOAP has entered, that's Government of Andhra Pradesh, has entered into agreement with KSPL for the development, operations, maintenance and transfer at the end of the concession period of Kakinada Deep Water Port. KSPL in turn entered into agreement with various service provider to fulfill its obligations under the agreement with GOAP. One of such parties with whom KSPL has entered into agreement is BSSPL, the SSC. Our agreement with KSPL is in accordance with the present agreement, that is the concession agreement between GOAP and Mrs. KSPL. In such a case, Mrs. BSPL, that is the SSC, steps into the shoes of Mrs. KSPL. And the condition of agreement with the central or the state government deems to be satisfied. In fact, we have submitted that the port certificate issued by the Port Department, Government of Andhra Pradesh in this regard. Further, we rely on the decisions of Hyderabad ITAT in the case of Belair Logistics Limited, which is squarely applicable to our case in Belair Logistics Limited, which are reproduced below. So this is, my lord, their contentions even before, my lord, this authority, that they wanted, my lord, that agreement to be deemed to be an agreement with them.
ট্রাইব্যুনালের অর্ডারে as such কোনো finding নেই ট্রাইব্যুনালের অর্ডার।
And my lord, if I might, my lord, most humbly indicate that, my lord, the tribunal, while, my lord, dealing with this issue, my lord, had not, my lord, specifically dealt with regarding these issues. No finding to this effect.
ফাইন্ডিং বলতে শুধুমাত্র অন্ধ্রপ্রদেশ গঠন থেকে সার্টিফিকেট পেয়েছে, দ্যাট ইজ দি কন্টেনশন। সার্টিফিকেট পেয়েছে, কিন্তু এগ্রিমেন্ট কিছু নেই, দেয়ার ইজ এ সার্টিফিকেট, দ্যাট ইজ দি কন্টেনশন। Page 13 দেখো, page 95, page 95, that is their only contention, যে সার্টিফিকেট পেয়েছে। Granted by of the
Page 95 of the application may be relevant, wherein, my lord, the tribunal had, my lord, recorded, my lord, the contention of the SSC, wherein, my lord, they had contended that they have got a certificate from the concerned government. Apart from that, my lord, there is no other, my lord, document to show that they are complying subsection B of section 4 of 80
Where is the CBDT circular dated 16/12/2005?
CBDT, that circular is not there. সেটাও আমাদের relevant.
It's a part of the paper.
Part of the paper.
Provided to my land.
This is paper book filed before the tribunal. It contains the concession agreement, everything.
Yes. This document, my lords, you will find it on page 195.
That is different issue. That is altogether different. ওগুলো কোনটা include হবে, পোর্টের মধ্যে কোনটা include হবে, that is altogether different.
Clause B.
This is
So the tribunal
Yes.
refers to this, stating that the condition, the rigor of that condition has been relaxed. If they are able to show an agreement that whatever is the build, operate, transfer or BOLT scheme or whatever is the structures are to be transferred to the authority on the expiry of a stipulated period, then it will be covered under the
That is totally different. So storage, loading and unloading, সেটা এই notification
that
include হয়েছে।
notification possibly, my lord, which my learned senior friend is showing to your lordship is with regard to, my lord, what would include in the definition of port. That has possibly, my lord, do not
yes,
have anything
that's
to
what
take
the
with.
tribunal also has
Yes,
referred.
That is different.
That is
Well,
different.
our
It doesn't have any bearing with, my lord, the issue in dispute.
Yes. That's it.
The my lord.
ওদের আর যে অর্ডার গুলো ছিল সেগুলো একটাও
But if my lords are, the tribunal has referred to the
পরে
agreement, but and my lords are pleased to see some of the provisions, but if I can just draw attention.
পরে
The tribunal note has, if my lords are pleased to have note page 86
থার্ড পার্টি
of the brief note.
Para 5.
My lords, paragraph 5.
In fact, there is one flow chart at page 91.
Lordship,
If you go to that, the first agreement is called the primary concession agreement.
my lords.
So government of Andhra Pradesh, the abbreviation is GOAP.
GOAP.
This ISPL is, what is the expansion?
But this was International Seaports Private Limited Singapore. This was the original agreement holder. Not the agreement in clause 2.9 provided for formation of a special project company.
One second. International Seaport.
Lordship,
So that's the primary concession agreement.
Lordship.
Then
The
under that agreement, they are entitled to
but the special project company was to be formed in terms of clause 2.9. The tribunal has adverted to that clause here. Now, under that clause, they had to submit the list of shareholders of that special project company. The approval had to be granted, and then on that basis, this subrogation took place. So, all the rights and obligations were vested in this
the
company.
primary concession agreement vested with the special purpose vehicle.
Yes, and that is that it was originally called Coconada Port Company Limited, renamed Kakinada Seaports Limited. So that's just a change of name. So this was the agreement, and then in terms of that agreement, this Kakinada Seaports has appointed the assessee. Now, before that particular work was taken up, this was a coal handling system for berth number 5. The customs authorities were approached, they granted permission for it to be set up. After it was set up, the port authorities, the government of Andhra Pradesh port authorities were approached, but they certified that it is a part of the port. And then there is also the provision in the parent agreement is that once the concession period ends, then it will vest in the government. So that part was also that is the position here, that was confirmed. Now if my lords are pleased to have that agreement once kindly have clause 2.9, which is at page 5, which is that formation of the special project company. Page 5 towards the bottom half.
Yes.
Is because I didn't mention that, didn't draw attention to page 2 where the parties are named. It was Governor of the state of Andhra Pradesh and International Seaports. Then it is recognized by the parties that ISPL is in the process of promoting a special project company, which will be a body corporate to be incorporated under the Companies Act 1956. The prior approval of GOAP will be taken on the shareholding pattern of the promoters in the SPC. GOAP will communicate its approval within 3 weeks of receipt of application by government. The parties agree here to.
Next clause is entitled to
Yes.
subrogate all its rights.
Shall be entitled to subrogate all its rights and obligations under this agreement in the form of an instrument in favor of the said body corporate. And then this was 2.9. Kindly also take note 3.1 at page 11. Tribunal has not adverted to it.
3.6 is it?
3.1, my lord, page 11.
Yes.
The GOP hereby grants permission to concessionaire to take over, but all these things are done with, and kindly see at the bottom of page 11, the last paragraph. The GOP hereby nominates concessionaire as its nominated agency for maintenance of harbour and common use of facilities and carrying out harbour improvement works, the costs of which shall be shared by the terminal lessees as per clause 7.5 and 7.6 herein. GOP will continue to be the port conservator, but delegate all powers relating to operation and maintenance of channel and harbour as given in Annexure B to concessionaire, and concessionaire will be responsible for all such powers delegated to them. Now, this Annexure B was not in the, was missed out in the paper book. I provided a copy to my learned friend, but kindly have a look at Annexure B. The government of Andhra Pradesh authorizes the concessionaire to undertake the following in respect of deep water port of Kakinada, which includes the port premises as defined in the agreement and the navigation channel, navigation areas, the breakwater, etc. associated with the deep water port of Kakinada. Government authorizes International Seaports India Private Limited to appoint its own nominee to discharge all the functions of the port conservator, but limited to DWP facility at the Kakinada port. The nominee shall have amongst other the following the powers, the following. Now, kindly see 13 and 17. Their powers were delegated. Now, the other interesting part is not kindly see at page 21.
71.
21, 7.3.
Yes.
Concessionaire shall share with GOP income to concessionaire on the basis of sharing percentages as given for various years in table 7.1. So the income which was being earned and this was being shared as per the table on the next page. So it was the powers were delegated. It was to run it as a port conservator. They could to carry out the obligations. They were authorized to appoint nominees. So this was the statement that clause 9 at page 25 regarding vesting of the 9.1 would
Transfer of assets.
transfer of assets.
Expiry of the concession.
Lordship, the first one is without reimbursement. The page 26 it is on payment of book value based on straight line method of depreciation. So whether it is of the any property there vested and so this was the background in which the tribunal decided the matter. And if my lords are pleased to see the decisions which have been referred to, kindly have that tribunal squarely address the controversy. It is not that the tribunal did not, at page 89, paragraph 7.1. The tribunal's order. They notice the second condition by subclause B. Either the undertaking which is being developed and operated, or developed, operated and maintained has to be pursuant to an agreement entered into it so and so. Now the question which is required to be answered is whether the agreement between the assessee and Kakinada Seaport satisfies the second condition prescribed. So they squarely address the point. My lords have seen that at page 90, the third line from the top. And then they
refer to the agreement. And then they refer to the customs permission, the port certificate. That is not in paragraph 10.
Customs approval.
Lordship. And the also not the government of Andhra Pradesh port certificate that it is a part of the deep water port.
So that it satisfies the condition in the CBDT circular.
Lordship. No, that it should be, and then kindly see at page 93, there's a reference to the judgment of the Honorable Gujarat High Court in CIT versus Ranjit project.
Yes, Ranjit projects and one Madras High Court.
Lordship. Now, Ranjit projects, there again, that agreement was not, there's no specific agreement, but the court said that, kindly have a look at.
Yes, in fact, they say a rigid approach should not be there.
Lordship, kindly have a look at that.
Para 13, they discuss about the agreement.
My lords. Yes, that is page 278. My lords have seen that. Paragraph 13.
After this so upon completion of the project, about 10 lines on the top.
My lords.
Entire infrastructure sold west to the government. Signatory so all practical purpose in the essence. Agreement between the assessee and the state government. Conscious of conditions so requires us entered in agreement of so. However, the rigid interpretation of this provision as canvassed by the revenue really result the assessee involved in genuine for on behalf of the government author. We denied the decision merely on the ground had created a nodal agency for.
And what special leave petition against this decision was leave was not granted. My lord said.
Yes.
No, the Madras High Court decision I had also not air logistics 374 ITM page 609. My lords, please similar the question which is at
Question number 3.
gotcha. And then page 615 paragraph 11.
Yes.
Under paragraph 12 of the tribunal, the Honorable Court was pleased to set out the tribunal's order. The relevant part of the tribunal's order, my lords, will find at page 616, the last bit, paragraph 7. Now we proceed to the next issue, whether in the absence of specific agreement with the central state government, local authority or state statutory body, the assessee is entitled to claim the benefit of section 80 IA 4.
Page 618, extracted paragraph 8.
Lordship, that's the tribunal's.
There may not be any specific agreement, but the sequence of events clearly show assessee is providing container freight facility in accordance with the condition laid by the government. No need to insist upon specific.
And then the reference is to the United Liner Agencies which is also not the decision cited by the tribunal in the order before my lords.
All right, we'll consider. Then what about the compilation of?
Lord, I will just come to that. No, this just the one thing, Lord, both this Lord, AL Logistics and Lord, the other judgment Lord, were before the Honorable Supreme Court Lord, in there's one more decision Lord, I need to draw attention. If my lords are pleased to see Lord, at page 94 of the tribunal's order. Page 94, Lord, the tribunal refers to the decision of the Mumbai bench in United Liner Agencies. Now, the same controversy with reference to circular, it was resolved. Not when this matter went up to the Honorable Bombay High Court, not the Revenue Council said that the position was covered by a Bombay High Court judgment. Not that the second question, basically, and it was submitted that it was covered by 374 ITR 670. But I've got that judgment. My lords, please see at page 651, question 4.
Yes.
Normally, the relevant discussion would kindly take page 670. But paragraph 38, where the section is set out, and what it is the section with which my lords are concerned with the as enforced today. And then would kindly see paragraph 39 at page 673.
Yes.
But paragraph 40, Revenue Council's argument is noted, not that there is no agreement. Then we'll kindly take paragraph 44, not where again the same argument is
Yes, recorded.
reiterated. Paragraph 44, not at page 674. Paragraph 47 at page 679. No, the Madras judgment is also
Refer to AL logistics, yes, sir.
And
Yes.
I had cited this decision on the previous occasion. 404 ITR 397, Commissioner of Income Taxes, Container Corporation. This was one of the object of the section is brought out here. Right. Paragraph 11, at page 405. This was, of course, the predecessor section. Now, it is, but the essence is the same. And these were appeals not against the appeals included not appeals against the judgment of the Bombay High Court and the Madras High Court. Kindly see at page 400. Just above the cases referred to, my lords will notice Continental Warehousing versus CIT was Continental Warehousing 374 ITR 645 and Madras High Court CIT was AL Logistics 374 ITR 609. But these have been affirmed.
So this Ranjit projects is not referred.
No, that is not them. That was the subsequent note where the SLP was rejected.
So this AL logistics has been affirmed.
AL Logistics and also not the Bombay High
Container.
and the Bombay High Court note. And because of that note, the Council for the Revenue note before the Honorable Bombay High Court conceded the position was covered by 374 ITM.
Yes.
Now, on the aspect raised by my learned friend, now the position in law, as I have found it, is that when it comes to the charging section, it is to be strictly construed in favor of the subject. When it comes to the exemption provision, unless the object of the exemption provision is to promote economic growth, the exemption has to be strictly construed against the subject, because he is seeking an exemption. So therefore, it is to be strictly construed against the subject at the point of entry. But once he is entitled to the exemption, then liberal construction has to be followed. Now, as I submitted, unless the object of the exemption is to promote economic growth, because in that case, the principle of interpretation is liberal interpretation. This has been, if I may refer to the judgment of the Honorable Supreme Court note, where this entire position is summarized. But kindly have a look at this. If my lords are pleased to have a look, page 617, paragraph 17. The positions, the extract set out under paragraph 17 mentions what I was trying to summarize before, my lords. Extract from wood papers.
in accordance with the objects sought to be achieved. Bajaj Tempo they have referred.
Lordship. So the court was pleased to hold not that the view which my learned friend was canvassing not that strict construction of an exemption notification, but that was held by the Constitutional Bench in Dilip Kumar's case. But they have noticed that not at page 622, paragraph 25. But what is important is paragraph 26 thereafter. 26 and 27.
So they draw a distinction, exemption provision, general, exemption provision for a beneficial purpose.
And promoting economic growth, that my lords would have seen the precise words in paragraph 19. But I think my lords have seen that. But our section is to promote infrastructure. So there cannot be any dispute on that aspect. Some of those decisions really, I think this is a summary of what the courts have been pleased to hold not from time to time. Yes.
My learned junior friend would like to address you with regard to that reply.
Now, my lord, the Lordship kindly see their compilation page 25. That is the the subcontracting power.
Page 25.
Page 25.
Yes.
This is the power of subcontract, and by this power the Kakinada Seaport and the SSC have entered into the agreement. Consideration shall be allowed or to subcontract enforceable during the subsistence of the concession period along with the other implement in obligation. Matter this agreement provided, however, the concessionaire shall be entirely absolutely responsible for any of the act, commission, negligence, default, breach of any and such as such subcontractor act is his breach or act, commission, negligence or default has been caused by the concessionaire on the agent or workman, and the concessionaire shall be solely responsible for this. The same. The here is SSC is not here. The SSC here is only the agent of the Kakinada Seaport. Only they are doing the work contractor. If I may say the work contractor, and not only that the judgment relying upon the senior friend here the court does not deal with the agreement. Third party agreement can be given the concession. But the judgment relied by the senior friend, all the judgment there are some dispute regarding the something related that the port not included, something like that. with the my lord, agreement with the assessee. It is not that my lord, the third party benefit to should be my lord, given. The all the judgment here, my lord, your lordship has to decide my lord, the case. In this case, my lord, where the agreement with the my lord, assessee with the Kakinada Sheet Court can be given the benefit to the my lord, exemption. Not only that, my lord, the learned tribunal, my lord, only my lord, relied upon the my lord, situation where the certificate has been given some authority and the my lord, the CBDT circular. Your lordship also already seen the CBDT circular. That is not different aspect, different point. Something not included that has been included. It is not that my lord, the somebody my lord, A, B, C, D, my lord, D will get benefit when there is no agreement with the D with the my lord, the government.
Government. As required under
Yes, my lord, that is my lord.
subclause B.
No judgment, nothing has been placed before your lordship that will not enlarge the scope that third party agreement can be given the benefit. Which the judgment placed before this honorable court and before the learned tribunal, there is something that had excluded some benefit that has been given, my lord. Not that third party given the benefit.
Yes.
I shall only indicate, my lord, these two judgments found to be somehow relevant because this is dealing with directly the fact that with regard to the situations where there is the question of entering into an agreement with the government or not, that was the issue. That has been dealt with in AL Logistic, which has been placed before lordship, relevant para, where, my lord, the ultimate conclusion was that the claim was denied on the ground that that condition was not fulfilled. So, my lord, in both these judgment, Ranjit Properties and, my lord, the AL Logistic, I believe, my lord, that is, my lord, that has enlightened to some extent with regard to the issue in dispute, and has, my lord, gone on to hold that since that condition has not been strictly complied with, the benefit that is, my lord, the ultimate purpose of this section could not be given to the assessee. So I found, my lord, those two, my lord, somehow relevant. And, my lord, with regard to, my lord, the other judgments, my lord, which I have relied on, that is, my lord, solely for the purpose of thrusting the issue that there is possibly no scope of, my lord, extending any benefit which is beyond, my lord, the clear words of the statute. Careful.
You have heard the submissions as judgment reserved. Two matters, is it?
Yes, two matters.
Yes.
So that's 85 and 86. Same assessee, my lord, separate assessment here.
Yes.
Separate assessment. I'm extremely grateful, my lord.
Seven.
On the last occasion, Mr. Om Narayan Rai.
Yes.
My lord, only one point I will raise. Assessment order was passed under section 144. The assessee did not participate.
Assessee?
Did not participated in the assessment proceeding. So assessee could not have submitted documents. In appeal before the CIT, the assessee produced certain documents. On two occasions, my lord. On first occasion, those documents, the remand report was called from the assessing officer. The assessing officer had submitted remand report. Subsequently, during the proceedings, the assessee again submitted certain documents. But in respect of those documents, the remand report was not called. Only at that point. And the CIT appeal had heavily relied upon those documents, which were part of paper book 2. My lord comes to page 32, 33, 34, 35.
No, it is not mandatory for him to call for a remand report. If he wants, he can call for. But the tribunal holds that the CIT has called for a remand report and also examined the documents.
But my lord, these are basically in the nature of additional evidences. Rule 46A3.
No, the CIT appeals enjoys the equivalent jurisdiction as that of the assessing officer.
My lord, I bow down to my lord, but here, my lord, these documents, the assessing officer should have given opportunity to examine, because here there are certain
The
transactions.
tribunal says that the revenue has not pointed out as to which findings given by CITA was not factually correct and or which of the documents furnished by the assessee was not believable. You are not able to point out that distinction.
My lord, may I point out the correct facts, my lord? What was happening, I filed certain additional, because it was 144 assessment, I filed additional evidences before CIT appeal with my submissions. Then he called for a remand report, and AO was hyperactive, and he was making further inquiries. So I had filed further, pursuant to further inquiries by the AO in the remand proceedings, I filed further documents before him.
Before the AO.
Before the AO. And that, for the sake of convenience, I had compiled in paper book number 2. And at the time of further hearing before CIT appeal, those documents were produced before the CIT appeal for the sake of convenience.
And the documents were produced twice before the AO.
All the documents were before that. That, my lord, is apparent from page number 28, my lord, internal page 10. Last para, my lord, para 5.2.1. The AO has stated in the remand report under serial number so and so that he had requested the assessor to furnish the copies of personal balance sheets for the assessment year 13-14 and 14-15. In response to the same, these were furnished before him. Please refer para 2 of the letter filed in response to query of the AO in course of remand report placed at page number 6 and 7 of paper book 2. The personal balance sheet as on 31st March 2013 is at page 20 to 22 of paper book 2, and personal balance sheet as on so and so is at page 25 to so and so of paper book 2. Please note the personalized balance sheet as on 2014 was also placed at so and so. So it was, all the documents were before.
All documents were there. Probably in 2, because he sought for further. Please come, sir. This appeal filed by the revenue under section 260 capital A of the Income Tax Act 1961 within bracket is directed against order dated 3rd April 2023, passed by the Income Tax Appellate Tribunal A Bench Kolkata within bracket Tribunal in ITA number 1901/KOL/2019 for the assessment year 2014-15. The revenue has raised the following substantial questions of law for consideration. Page 8, 1 and 2. We have heard so and so. The revenues on appeal are being aggrieved by the order passed by the tribunal, rejecting the appeal filed by the filed by the revenue, challenging the order passed by the Commission of Income Tax Appeals, Siliguri, within bracket CITA, dated 11/4/2019. Before us, the only ground which has been urged by on behalf of the revenue is that during that the assessee did not participate in the assessment proceedings, and therefore the assessing officer completed the assessment under section 144 of the Act by order dated 27/12/2016. When the appeal was filed, the assessee produced certain documents and before the appellate authority, and a remand report was called for. However, after the remand report, fresh set of documents were filed before the CITA, which were not sent for verification to the assessing officer, and the CITA proceeded to rely upon those documents and granted relief to the assessor. To examine as to the correctness of the said submission, we have perused the order passed by the CITA, more particularly in paragraph 5.2.1. From the said paragraph, it is evident that that the assessing officer in the remand report had requested, the assessing officer had requested the assessor to furnish copies of the personal balance sheets for the assessment year 2013-14 and 14-15. And in response to the same, they were furnished by the assessee. And these documents were filed in the form of a paper book, number 2. Further, the personal balance sheet as on 31/3/2013 and the personal balance sheet as on 31/3/2014 also formed part of the said paper book. And these were all placed before the assessing officer during the remand proceedings. Therefore, the revenue is factually incorrect to contend that the CITA relied upon documents which were never produced before the assessing officer. Furthermore, the tribunal, after analyzing the facts of the case, has pointed out that the revenue has not pointed out as to which of the findings given by CITA was not factually correct, or which document furnished by the assessee was not believable. Thus, we find no question of law, much less substantial question of law, arises for consideration of this appeal. Consequently, the appeal fails dismissal. Yes, thanks. Next.
My lord, I'm giving the name of Mr. Rai.
Rai also, Mr. Om Narayan Rai. And next.
Item number 8, 9, 10.
Yes.
My lords, these are 3 matters, 8, 9, 10. They pertain to assessment year 16-17, 17-18, and 18-19. The issue is, my lords, that whether section 115 JB is applicable to DVC, that is the petitioner, who is a electricity generating and supplying
How
company.
much time you will take?
My lords, 5-10 minutes, not more than that.
Because
for admission.
1 o'clock we will have to close.
Lord, I will be showing certain judgments.
So let it remain in the list. Any short matter is there?
Short name. No short.
No short.
That is not a short matter, my lord. 11, 13, 14, 15, my lord, same.
But not short matter.
Not it's not a short.
Admission coding, sir.
What is 16?
16.
Ritu Doria.
Admission.
The 16 fact, there's a covered judgment of your lordship, Miller, which on the last occasion was pointed out, and your lordship will see the covered judgment is reported in 376 ITR. Mr. Sivaraman.
Got a copy of it?
Millard.
Milords, I'm here for the respondent, Milords, this matter.
Yes, Raghav.
Milords, the only issue for your lordship's consideration, Milords, is that the filing of the form 3CA, whether it is possible to file in the assessment proceedings or should have been done before the due date. In fact, your lordship was considering similar aspects in 80 IC, your lordship will recollect. A form 10 CCB was filed during the course of the assessment, and that is not proved to be a fatal for a claim of a reduction. That is the only issue with your lordship's consideration. In fact, the Supreme Court's decision in GM knitting is followed in that matter.
Please come. This appeal by the revenue filed under section 260 capital A of the Income Tax Act 1961, within bracket the Act, is directed against the order dated October 3, 2023, passed by the Income Tax Appellate Tribunal, C Bench, Calcutta, within bracket tribunal, in ITA number 444/KOL/2023 for the assessment year 2018-19. The revenue has raised the following substantial question of law for consideration. Page 5, A only. Sir. We have heard Mr. Ariyak Dutt, learned senior standing counsel for the Learned Senior Standing Counsel, along with Mr. Prithu Doria, Learned Senior Standing Counsel, and Mr. Raghav Menon, Learned Advocate, appearing for the respondent SSC. The substantial question of law raised for consideration before this court is squarely covered against the revenue by the decision of the Honorable Supreme Court in Commission of Income Tax, Maharashtra versus GM Knitting Industries Private Limited, 2015 376 ITR 456. Thus, following the said decision, the appeal filed by the SSC, the revenue is dismissed, and the substantial question of law is answered against the revenue.
I'm deeply obliged to your lordships.
In this case, in this case, there was an affidavit filed by the CA also, which is also covered by your lordship's decision.
Which one? Item 17.
12, my lord. It's covered because of the tax effect, my lord. Because on the question suggested.
Which item?
12, my lord.
12 is low tax. Tutoria, 12.
Yes, yes, yes.
Because in the question suggested, my lord, the tax effect is.
12.
Yeah, this is the court of judgment
That is
of
also
the
appearing, Lord. Lordship.
In this matter, a lot of things has to be said.
Which one? Item 12.
Yes, it will take some because we have to.
Okay. Then let 12 remain. Let it remain in the list. 1 second. Item 17.
17
for the respondent, your lord.
Lord, 17, I'm for the appellant. Here also, my lord, that this is regarding a 271 1C penalty order. My lord. In the penalty, my lord, the relevant was not strike out. My lord, so, my lord, there is a court. No. There is a coordinate bench of this High Court. My lord, there is an order, my lord, where the appeal was allowed in favor of the SSC respondent. My lord. I have to cite those judgments.
Below one.
Below the tax effect.
Below tax effect.
No, it's not below tax effect. My lord,
you see the computation.
Lordship can say. But this is a penalty matter, my lord. So here the tax effect was a penalty matter, my lord. It's not 271 1C
But
penalty.
tribunal has referred to
Yes.
so many decisions of this court.
Tribunal has referred, but my lord, recently, my lord, there's a judgment of our court.
This is Surya Prakash case.
Yes.
Lordship, this
That-
is a circular, your
That, my
lordship.
lord, in that is in favor of the revenue, my lord. That is in favor of the which says, my lord, the strike. Even if it's not strike out, but it doesn't mean that they will get the benefit of the benefit will be given to the SSC, my lord.
No, does that judgment consider all the earlier judgments?
My lord, some of the judgments are considered in that.
Where is that judgment?
My lord, just Lord.
All right. Next hearing you produce. You give copies to Mr.
Yes,
Chairman.
I'll give him.
Yes, madam.
Serial number 20, my lord. Mr. Sharma is there. They have relied on circular, but it is not at all applicable for tax effect. The assessment order is 26 lakhs 80,000. Tax effect is 50,000. CIT cannot.
26 lakhs only, they say.
Yes. And the circular nowhere stated the exception clause.
You have not verified it.
I will verify. I have seen the.
Yes, my lord.
All right. He is not ready today. All right. We'll stop with this.
My lord.
Mr. Sir, you are logged in for item 18.
My lord, I am logged for item 18, my lord.
But today we will not be able to take up, sir.
My lord.
Thank you.
Thank you, my lord.